mistake. Now you would have seen that we have discussed those factors the presence of which makes the consent unfree. That is, the free consent, the free thing of the consent becomes absent. Because when there is coercion, the consent is not free, it is made under pressure. When there is undue influence, again the consent is not free because it is made under influence. Even when there is fraud, the consent is obtained by deception, so the consent is not free. Under misrepresentation, the consent is obtained by making a false statement, though the intention to deceive here is not present. Same is the case with mistake. When the parties are under mistake, we can say that the consent is not free. Rather, there is no consensus ad idem. Because if one party thinks he's selling cotton and the other thinks he's purchasing wheat, there can be said that there is no contract between them. Again, the consent that was given to each other, it was vitiated by mistake. So all these things lead to the consent not becoming free. And since the consent does not become free, that is, free consent is absent, the contract becomes voidable. But mistake is a special case. In the earlier four cases of coercion, of undue influence, fraud, and misrepresentation, the consent was mixed with these things. However, in case of mistake, the consent is assumed to be absent. There is no consent. The consent here is not given under pressure. The consent here is not given under influence or under deception. The consent is assumed to be absent because one party thinks of something else, the other party is thinking of something else. So they are not agreeing to the same thing in the same sense. So we say that there is no consent and thus there is no contract. And this is the reason why under mistake the contract becomes void. Under the earlier four things, coercion, undue influence, misrepresentation and fraud, the contract became voidable because consent was there, it was not free. It was mixed with other things. Here, the consent is assumed to be absent and thus the contract becomes void. But do you think all contracts done by mistake are void? No. Let's see what are the contracts which are void and what contracts remain valid. Now, Indian Contract Act defines mistake as two types, mistake being of two types, mistake of fact and mistake of law. Now, what do you mean by mistake of fact? Mistake of fact means it's a fact relating to subject matter. It relates to subject matter. So, there is a mistake that has been committed about some fact about the subject matter. Let's say I tell you, I want to sell Egyptian cotton to you, and you assume it to be American cotton. You think it is American cotton. So now there's a fact about the subject matter. Subject matter here is the cotton. So there is a fact relating to it about which the mistake has been committed. I intend it to be Egyptian cotton. You assume it to be American cotton. So there is a mistake about a fact relating to the subject matter. There can also be a mistake about law, some provision about law. Some provision of law has been misinterpreted, or probably we do not have the knowledge about some provision of law, and in the ignorance we make a contract. So let's see now how the mistake of fact is bifurcated and how the mistake of law is bifurcated. Let's take mistake of fact first. Mistake of fact is divided into two parts, unilateral and bilateral. Unilateral means one person. Uni means one. So this is a mistake which is committed by only one person. Bi means two. That means both the parties. Both the parties in the contract have committed the mistake. So when the mistake is unilateral, the contract is valid because the mistake has been committed by only one person. Why should the other person suffer because of the mistake of one person? The other person should not suffer or make a loss, or he should not be made to cancel the contract just because of the mistake of the other party. If only one party has made the mistake, the contract remains valid. However, if both of the parties have mistaken, then in that case the contract gets avoided. The contract becomes void because both the parties have committed a mistake. Whom should the blame be put on? Nobody can put the blame on the other party because both the parties have committed a mistake. There is a mistake on the end of both the parties, so the contract becomes void. When the mistake is from the end of one party, from one party's side, the contract remains valid. If it is a bilateral mistake, then both the parties have mistaken, the contract becomes void. This is how mistake of fact is divided. Now let's come to the mistake of law. As I said, mistake of law means misinterpreting law or being ignorant about some provisions of law. So mistake of law has been divided into mistake of domestic law, that means law of land, that is law of the land of which you are a citizen, you are a resident, you are a national, and mistake as to a foreign law, that is law of a foreign country of which you are probably not a resident of or a citizen of or a national of. Mistake of domestic law is valid. Now this is because ignorance of law is no excuse. You should know the law of your land. And this is the reason why we are studying law now. Why are we studying law? Because you are doing a course which probably is related to the financial or the corporate field. And why should you study law? You should study law because this kind of law relates to your field of expertise. CS would study a law which is more related to companies. A CA would study the laws which is more related to business, about taxation, about audit. Now, similarly, a medical student would study a law which is related to medicines, the use of medicines, the use of drugs, adulteration of medicines, expiry of medicines. So, this is the reason why we have law as a subject in our study, because the law itself says ignorance of law is no excuse. You should know the law of your land, and if you are ignorant about it, the law will not give you the excuse of saying that you do not know the law. If you enter into some contract, let's say you enter into a contract of gambling. Now we know that gambling is void in India. or probably you enter into a contract of wagering. Again, the contract of wagering is void in India. You cannot say, I did not know that the contract of wagering is void in India, hence it should remain valid because I did not know. No, it would not work out this way because law says ignorance of law is no excuse. And if you are ignorant about law, please consult some expert who is an expert in law. Please consult some lawyer before taking your decisions. If you do not study law yourself, take the help of a lawyer. But a mistake of domestic law will never be accepted because law says ignorance of law is no excuse. This relates to domestic law. You should know the law of your land. But are you required to know the law of every country? No. You are not required. You are not expected to know the law of all the countries. So, any mistake which is made about the provisions of a foreign law probably will be decided as if it was a mistake of fact. Then it will be seen, was it a unilateral mistake or a bilateral mistake. If both the parties committed a mistake about the foreign law, it will become void. If only one party committed a mistake about the foreign law, it will remain valid. So it will be considered same as a mistake of fact. Like in mistake of fact, here also it will be seen if the mistake about the foreign law is unilateral or bilateral. If the mistake about foreign law is unilateral, the contract will remain valid. If the mistake about foreign law is bilateral, that is on the part of both the parties, the contract will be avoided. It will become void. So, this is how mistake has been explained in the Indian Contract Act. Any contract made on account of mistake is generally void because it is assumed that both the parties would have committed the mistake. But if only one party has committed the mistake, the contract remains valid.